We represent the respondents, the University of North Carolina, today. In today's case, there's one question before the court: that if race-conscious affirmative action is consistent with the 14th Amendment to the United States Constitution. The UNC, when you are applying race, is considered when a student wants to join the university. Race should be considered when applying for a university or college. There should be diversity when thinking about approving a student to the college. So when the University of North Carolina denies approval of joining the university due to race, it shows that there should be more consideration when applying to Black and Mexican communities. There are stereotypical views showing that Mexican and Black people are considered bad people, even though we want equality. Society has changed that view, showing people of color standing up for themselves. And yet there's still being inequality and problems, but some changes with people of color has been recognized, like the case of George Floyd, a Black man who was killed by a police officer. We all knowing it was wrong, but had people of color, mainly the Black community, protesting for one of their own people, showing how race will be exaggerated when needed to. What I'm explaining to the court is that counting race and showing race being applied to college applications is needed to show group following, but also comfortness of having people like you around you. So that one of the reasons to put race in the decision when applying for a student is college, university, and to a part of the decision is the second college or universities into the part of the decision. The second point I would like to bring up is that you can see the experience that the individual has gone through, showing their ups and downs of being their race, and letting us see what the student is like because of the race. Are they getting hatred towards the Are they getting hatreds towards of the cause of their race because of their race, or the benefits because of their race? Recently, the Asian community has been getting a lot of brutality because of their race. This could be an example of what the Asian students might go through, showing that they've been able to They've been able to move on. Now let us move on to my next point. Does the Equal Protection Clause of the 14th Amendment prohibit race-conscious affirmative action? No, it does not prohibit affirmative action, because the Equal Protection Clause does not have anything affecting affirmative action. The Equal Protection Clause says that no state shall make any forced law which shall abridge the immunities of the United States, which implies that everybody has equal right to learn the same way as everybody else, which implies that learn the same way as now this does. This sounds contradicting to what me and my partner are trying to prove, but this shows that everybody has a right to learn. But that does not mean that race is going to stop individuals from learning. It talks about the right being removed because of their color of their skin, not the approval of letting them into the schools. The legislation enacted by Congress of 1860s and 1870s shows that the control of education should be left to the states and only the states, shown in President Andrew Johnson's veto of the Freedmen's Bureau Bill on February 19, 1866, showing that the decisions of education is left to the state, not the school. Left to the state, not the school in particular. And then the example from one of the legislation debates in Congress, the Globe 38th Congress, first session to 2799 in the year 1865, also describes that Mr. Charles Sumner, a Republican senator from Massachusetts, spoke in favor of the establishment of a bureau that would provide educational privileges to freedmen and aid to those in need. What would become the Freedmen's Bureau? Sumner believed that situations for the freedmen's southern state was dire. His support of the act was based on the belief because the newly freed slaves deserved their freedom from legislative and executive acts of the United States government. This showing that there is recognition of equality when talking about back then. It was very different now. 150 years later, this has changed due to the fact that it has gotten even better than it has before, with people protesting and there being more recognition and standing up for themselves. This could also be the reason why framers of the 14th Amendment wanted to African descent to have special privileges, due to the fact that people who were slaves, African descent wanted to have special privileges due to the context of slavery, showing that they wanted to help people who were slaves. There should be fairness between the race. Can this affect the LGBT community? Now, this cannot affect the LGBT community because of the writers of the 14th Amendment only purpose was to help people of color. Back then, being homosexual was considered a thing we don't talk about. So in present day, it's considered okay to be gay. But back then, it was something people didn't discuss. And the writers of the 14th Amendment had no thought about the gay community and only focused on people of color. So this cannot affect the 14th Amendment cannot affect the LGBT community or the sexual view of the person themselves just because themselves being gay would have no effect on them getting into school because of their sex orientation or of themselves. If there are no further questions, I would like to pass it to my co-counsel, Joshua Yu, who will address more about affirmative action being consistent with the 14th Amendment.
Hello, my name is Joshua Yu, and we represent the University of North Carolina. Race towards college admissions should be expressed throughout the United States and expand the idea of applying race towards college admissions. Races like the black community and the Hispanic community are generally stereotyped. For example, the black community are stereotyped by being called murderers, Uncle Tom, etc. And for the Hispanic community, they are normally called border hoppers and more. Comparing the Hispanic community and the black community to the white community shows that naturally the white community is favored more between the Hispanic and black community. For example, if there is two males, one being named Benjamin and the other being and is a well-off white male, and the other being named Marcus and not being as fortunate, but has better educational values than Benjamin. But Benjamin would probably have a higher chance of getting admitted because of their status and that they are a race that is favored in this society. The reasons why all these bold claims are being made is because race being an important factor in a person's admission and keeping it the races that were highly discriminated for a long period of time, like black and Hispanic people. Adding on what my partner said about the Asian community is that the discrimination of Asians wasn't as popular and was really disregarded. But towards the college admissions side, Asians really shouldn't have the benefits and insurance like what the black and Hispanic people are getting. Is because really they aren't as recognized and not really as popular comparing to the black and Hispanic and the white communities. Affirmative action was upheld by the Bakke and Gutter case, but is only allowed a few times. But if affirmative action is used, then it would be breaking the law. To go more in detail on the Bakke case, it is about a man named Harlan Bakke, who was a Californian man that applied and was rejected twice in getting accepted into the medical school at UC Davis. And after both outcomes, he decided to sue the school. And him being white should have an extra boost above the rest of the other races because it was a norm back then as well now. Harlan had higher test scores than the minorities that were accepted, and back then the white applicants were normally given the upper hand because of their skin color. So even though an Asian applicant that had higher scores compared to like a white applicant that had lower test scores, a white applicant will be granted a higher chance because they're admitted. Chances of getting admitted because of their skin color. It's also important to know that not having much diversity throughout the UNC and throughout the whole United States could help knowing the same races that you are, and not having many minorities in the school, as well as not expanding much minority face. Moving on to Gutter v. Bollinger, the case was about the University of Michigan Law School. We're using the racial preparations on who to accept into the law school, and not really caring of the academic background. The importance of the Gutter v. Bollinger case is that it gave everyone a fair chance in getting accepted, as well as what it upheld affirmative actions at the school. By having the racial perfection could help the people of the same race know each other than having other races just interfering with the race that is preferred. The continuation of racial preference is most needed to stay for the time being because it helps universities reduce the expansion of different races they have decided on and just really focus on one or couple or a couple races, making competitive to the preferred races while having some competition to the not so preferred races. The court shall have it go for the time being because of just how it can be a difference maker towards the factors that less diversity means that there would be less stereotyping towards one and another and is just beneficial. To more about the Gooder v. Bollinger case, the overturning of it would be very beneficial in many ways. For one, the Michigan Law School could make quicker decisions and be less focusing on the races they choose on, addressing the discussion of stare decisis. Addressing this discussion of stare decisis in Dobbs v. Jackson Women's Health Organization. The importance of this case is that it is about abortion and how in the Constitution it doesn't grant the right to have abortions or any sort of killing of a unborn child. The similarities between these cases is that they are a group of parties that are arguing for fairness, or that it's just proving something that you believe in that is getting debated by the other party that believes in the opposite. The succession of plaintiffs, if Gooder v. Bollinger to be overruled, will be a rejection. There's many logics in why this is being said. For the petitioner, for one, the petitioners did have some very few valid claims. For instance, when they stated that the affirmative action was supportive to the minorities like African Americans, Native Americans, Hispanics, and more. But even though this action was created, the university still did the opposite on what this action was created for. This is many reasons on why universities use race-based opinions for the university. For one, race-based opinions. For one, the university was created or owned by a non-minority race like white, and etc., as well as the location of the area. The selection of a diverse military personnel wouldn't be difficult as thought of. For one, the selection for higher ranked positions would be more difficult for the non-minority races because there would be more the same races and less of the minority races. To add on more about that is being said, it wouldn't have to assign the African Americans, Hispanics, and more frequently. The sum of everything that is being said in this argument, race towards college admissions, is an important factor in so many aspects in the college life and a ton more. And spreading it all across the country would. The court case about how colleges are using race towards college admissions. For instance, University of Michigan and their law school about the law school were admitting applicants based on their race, and based on that, the importance factor is that having less diversity at the school and all across the country can have equality. Thank you.
Race to factor in college admission is one of the most important things in the college admission. It could be a make or break the application's acceptance, and express all across the United States would be the best in making college and universities less discriminating and diverse. Bringing up the Gooder and Bollinger, it was expressed that race wouldn't be used in admissions towards the University of College Michigan Law School. And the outcome was very controversial due to the weight and race needed to stay because it helps lower the decisions in the admission officers and has more benefits.
Does the Equal Protection Clause of the 14th Amendment prohibit race consensuous affirmative actions?
Could you repeat the question, please?
Alright. Does the Equal Protection Clause of the 14th Amendment prohibit race continuous affirmative action?
No, it doesn't, because it has nothing to do with, it isn't prohibited affirmative action of anything. It does not have anything affecting affirmative action to the Equal Protection Clause. That says that the Equal Protection Clause says that no state shall make or enforce any laws which shall abridge or immunities of the citizens of the United States, which implies that everybody has the equal right to learn the same way.
All right. Number 2. How does legislation enacted by Congress in the 1860s and the 1870s affect your answer to question 1?
Legislation enacted by Congress in 1860 and 1870 shows that the control of education should be left to the states and only the states.
All right. Number 3. Let's assume that the framers of the 14th Amendment concluded that race-conscious legislation was constitutional in the 1860s and 70s. Would that argument still work more than 150 years later in a very different society?
Well, the framers used their belief because the newly freed slaves derived their freedom from legislative and executive acts of the United States government. That's showing that their recognition of equality when talking about back then and then now. It is very different 150 years later. That has changed due to the fact that it's gotten even better than it has before.
Right. Number 4. Let's assume that the framers of the 14th Amendment thought that people of African descent deserved certain race-continuous privileges due to a unique context of slavery. Would the framers have argued that members of other races, such as Hispanics, Asians, and Native Americans, could receive similar privileges?
The framers of the 14th Amendment wanted there to be special conditions for the African Americans, but they also wanted to apply it to other races.
Number 5. What would the framers of the 14th Amendment have thought about affirmative actions politics that benefit people on the basis of sexual oriented or general identity?
This does not affect the LGBTQ community, and when you want to get into a college, there isn't any sexual orientation applied to the college admissions.
Ready? Number 6. Does Brown v. Board of Education 1954 prohibit race continuous affirmative actions? In your answer, please address Blake and Gordon.
Can you repeat that question?
Alright. Does Brown v. Board of Education prohibit race continuous affirmative action? In your answer, please address Blake and Guter.
Affirmative action was upheld by the Bakke and Gutter case, but is only allowed a few times. But if affirmative action is used, then we'll be breaking the law. To go in more detail, in the Bakke case is about a man named Alan Bakke, who was a white Californian man that applied and was rejected twice in getting accepted into the medical school at UC Davis. And after both of the outcomes, he decided to sue the school, and him being a white should have an extra boost above the rest.
Alright, number 7. In 2003, Gutter observed that 25 years and the use of racial preferences will no longer be necessary to further the interests approved today. Will there ever be a point in time in which race preference are no longer needed? If not, should the court allow race preferences to go on forever?
Moving on to Gutter v. Wellinger case. The case was about the University of Michigan Law School was using racial preferences on who to accept into the law school and not really caring about the academic background. The importance of the Gutter v. Wellinger case is that it gave everyone a fair chance of getting accepted. As well, it upheld affirmative action at the school. By having the racial preference could help people of the same race know each other, and having other races just interfering with the race that is being preferred.
Alright, number 8. Should Gutter v. Bowler be overruled? Please address the Supreme Court recent discussion of state decent and Doug v. Jackson Women Health Organization.
Addressing the discussion of stare deceased in Dobbs v. Jackson's Women's Health Organization, the importance of this case is that it It is about abortion on how, in the Constitution, it doesn't grant the right to have abortions or any sorts of killings of an unborn child. The similarities between these cases is that there is a group of a party that is arguing for fairness, or that it's proving something that you believe in that is being debated by the party that believes in the opposite.
Alright. Number 9. If the court declines to overrule Gutter, can this plaintiff prevail?
The succession of the plaintiffs, if Grutter v. Vollinger to be overruled, would be a rejection. There is many logics in why this is being said. For one, the petitioner did have few valid claims. For instance, when they stated that the affirmative action was being supported to the minorities like African Americans, Native Americans, Hispanics, and more. But even though this action was created, the universities still did the opposite on what this action was created for. There is many reasons on why the universities use race-based opinions. For one, the university was created or owned by a non-minority race like a white and etc., as well as the location of the area.
Alright. Number 10. The last one. If the court overrules Gutter, will the military have discussed recruiting a diverse armed service?
The selection of a diverse military personnel wouldn't be difficult as thought of. For one, the selection for higher ranked positions would be more difficult for the non-minority races because there would be more the same races and less of the minority races. To add on about this, it wouldn't have to assign the African Americans, Hispanics, and more frequently.
Thank you.